afternoon, folks. I'll probably talk fast here because there's a number of things I want to cover, but I want to start out with a challenge. I'm eliminating John Relman from this challenge because he can probably top me on this challenge. But I would love to see every single one of the lawyers here who is in a position to handle a case, handle one of these cases, because when John and I first talked about the presentation and what we were going to do and how we were going to do what we were going to do, John said something, and he's repeated it, and I heard it in something that Natalie said too. These cases are fun. That was John's word, and that's really one of the things that I've always approached these cases. They can also be very difficult, they can also be very challenging, and you can also have lawyers who decide they want to take your body parts from you in the course of litigating these cases, but essentially they are fun. And so here's the challenge that I'm going to give you. It's in your materials, don't need to look at it, but I'm going to tell you about a case, and then I want to spend most of the time that I have talking about testing and testing as it works in a complaint. A lot more years ago than I care to think about. Cliff Schrupp at the Fair Housing Center came to me and approached me about doing a case which was before we had handicap in the Fair Housing Act. And this is the story. We have two developmentally disabled men, one of whom was raised by his parents at home and one of whom spent his whole life in an institution. And you could tell the difference just by looking at them. One of them was hunched over, very seldom talked to anybody, wouldn't look, neither of them could speak. But the one that was raised at home, you know, looked healthy, looked like he had been raised by somebody that cared about him as opposed to the other individual. They applied to live in a housing cooperative in Milford, Michigan, and that's on the other side of John's map there. There aren't anybody, including many handicapped folk, in Milford. They were going to have someone from an organization who would be with them 24 hours to care for them. They applied, they would go back, and they would always get, you're on the waiting list, you're on the waiting list, you're on the waiting list. Now understand, this is a HUD, with all due respect to the HUD people in the audience, this was a project that was financed through HUD. So all the people that are living there are income-based to be able to live there to begin with. They kept getting turned down, they kept getting told that there was nothing available. This goes on for a couple of years. One of the people in the group drops out, another one comes in. So there's David Allen and John Hanna are the two individuals involved. And they applied again, and again they kept getting the runaround. So the Fair Housing Center, with the inimitable wisdom that Cliff Schrupp had, and it really was inimitable wisdom, said, we're going to send two non-developmentally disabled adults who are not related to each other, so we're going to try to get marital status plus handicap into this to test the place. And of course, there were units available for those folks. So we filed suit, and with the inimitable wisdom of a judge, he denied my temporary restraining order to block them from renting or from selling any of the units that were available. So there is in the materials, and I provided it, and I provided it on another case we're going to talk about, some background on a preliminary injunction. So you've got some documents. So if you ever had a case like this, you go there. So of course we get in the preliminary injunction. We had a very good judge, Horace Gilmore, who was a very liberal-leaning judge, and lo and behold, we're there, and there's no units available. But there had been at the time that this happened, and that they had leased, or they had sold the units in between. Well, I've seen judges get hot before, but I swear I thought Judge Gilmore was going to, you know, we were talking, Natalie's talking about these high things. I thought he was going to jump over the bench and strangle my opponent, because there were units that had been available. They sold them all in the meantime. So I've got Saul Green, who was the attorney for HUD at the time. He's there to testify. I've got a HUD rep there to testify. And we've got all of this stuff that we're doing to testify. And in the middle of all of this, the attorney for the cooperative says, you know, I just got a call from the cooperative. He didn't have a cell phone in those days. That'll show you how old that was. We have an available unit for them. Okay? So, a couple weeks later, the Fair Housing Center folk and me and some other folks helped these two gentlemen move into this unit so that they can have their unit to themselves for the first time in their lives, that they're going to be independent and living in a housing cooperative together. And while we're moving them into the unit, somebody from a unit a ways away from where we were observed what was going on and saw the two men and came out and asked what was going on. And we explained what was going on. And they brought out their daughter, who was developmentally disabled, who was living in their unit, and they had been hiding her in their unit because they knew that the folks that were running the cooperative would not allow someone with a disability, a developmentally disabled person, to live in that cooperative. Amazing, huh? So what I'm telling you this story for, first of all, we get housing, and candidly, oftentimes in fair housing cases, and Chui and Steve can testify to this, as can John, most of the time, the housing's gone by the time you get there. And so the person that you're fighting for, candidly, you're fighting for the money that oftentimes isn't there that Natalie was talking about. But here you've got a situation where we get two people housing that they deserve to have. And we get somebody who brings their daughter out of the closet so that she can live in the co-op like everybody else, because she has a right to do that. Can you beat that? Well, you can't beat that. Now, in the course of the litigation, I'm deposing the manager, who was very sympathetic. And she quoted one of the board of directors as saying, and I know that Natalie said that folks don't talk like, I mean, it's different and that people hide stuff. I have some crazy theories that we won't go into today, but I think that white folks and people that are hell-bent on discriminating, whether it was in 1988 and 2014, still talk and act like that to what they think is a sympathetic audience, another white person. And they'll say stuff to another white person that you would be stunned that they would say. And this member of the board of directors said, literally, and these are the words, so we have to keep in mind there's a camera over there, we aren't going to let any fucking retards into our complex. Now mind you, they're all subsidized. They're all living in a subsidized housing. They're subsidized themselves in their housing, but they're not going to let any developmentally disabled people in this house. Well, we settled that case for a handsome amount of money and gave them, these two gentlemen, enough money to live off in their unit for a long time. But the case doesn't end there. You know, it would have been wonderful just by the self of that family bringing that developmentally disabled daughter out. Didn't end there. The cooperative had a management company. The cooperative management company learned from all of these kinds of things, and as a matter of fact became one of the stellar management companies in the state of Michigan in terms of representing and making sure that the entities they represented fully complied with fair housing laws. And some years ago, this organization decided that they, I guess because I'd been around long enough, that they were going to give me some kind of an award for doing something. They gave me an award, and at the same time they gave this management company an award. But that isn't where the story ends. The president of the cooperative at the time that this all happened, who was outraged by the behavior of his fellow board of directors and what they did and how they did it, because they voted, and he would always get voted down on these issues, decided that he was going to make his career being a manager of complexes, okay? And formed his own management company. His name was Bob Beal. Well, 6 or 7 or 8 or 10 years ago, the years go by and you forget how quickly they go by, there was an apartment complex in Livonia at Middle Belt and 8 Mile on the other side of the coin, so to speak. And the owner of that complex, Whispering Woods, now called something else. Mike, what's the name of that complex now? Mike, what's the name of that complex now? It used to be Whispering Woods. Apple something or other?
Apple,
Yeah,
Apple
whatever.
Valley or something like that.
They go to Bob Beal's company to hire him to manage the complex. And Bob doesn't know anything. Here's a complex for him to manage. But the owner says to Beal, we're not allowing any African Americans in here. You're going to be the manager. That's part of your role, is to keep African Americans out. So there's a little cycle here. So Bob Beal reports this to the Fair Housing Center, who had tested this place before, hit them up for what, $100,000 before that?
First time, yeah.
Yeah, and tells them, like John's case that he was talking about with the person from Wells Fargo, it's got the first-hand information. He says, this guy offered to hire me, but told me specifically that I couldn't rent to anybody. Fair Housing Center with the Justice Department, Judy Levy, and that brings a case, Saul Green at Miller Canfield brings a case against them. And what was the ultimate judgment, $707,000?
Uh-huh.
So here's the point of the whole thing, and I've spoken too long about this, is beat me. Tell me when you handled a fair housing case, and you could say that you could see what you did that accomplished as much as my case. Call me in the nursing home when I'm 90 years old and say, Obee, I've beaten you. I've got a case that did more. I've excluded him because he's probably can tell about 20 like this. But my challenge is to you. You show me how you can have more fun and accomplish more by one case. Who knew all this stuff was going to happen? All I knew going into this is we didn't have a statute that worked, because we had to go under the rehabilitation statute. We weren't even sure we could use that as a basis for doing it. I wasn't going to be in state court, because I'll tell you, you don't want to be in state court, not here in Michigan, because it's the death of you if you're in state court. But there was a case I had some handle on that Fred Mester got in Oakland County when I was a referee for the Department of Civil Rights. That worked, but generally speaking, you don't want to be in state court, so your choice is federal court. And you got to figure out a way to do it. And here you find over a 25, 30-year period of time that what you did with this one little individualized case had all kinds of consequences from it and led to some really wonderful things that happened. Beat me. Do better than that. That's my challenge to you. I want to see all of you here that are in a position to handle a case, and do better than that, and call me and tell me you did that. Okay, so now I want to talk about testing, because Natalie talked about testing in one context, and I want to talk about it in another context, which is what happens when the Fair Housing Center brings you a case, and they bring you this wonderful evidence. They've been out there, they've sent 2 testers, 4 testers, whatever, and they have this really strong evidence of discrimination going on. And you have in your materials, and I'm going to just walk through a couple of these cases, because I have a philosophical bent about the handling of these files, and I'm sure John and Chui and Steve could debate with me about doing them. But I generally, when I file a complaint, I don't ever mention there's testing evidence, ever. I'll explain why in a minute. But the very first case you have in your materials that I did for you is a case called Champ versus Bowman. It's a reported case in the Western District of Michigan. For those fans of the Western District of Michigan. And in that case that you have, not only do I outline what occurred to the plaintiff, I outline what occurred to the tester also. And there was one tester. Normally, in virtually every case you're going to get, you're going to have a protected tester and a comparison tester. Sometimes, in some situations, and it seems like Cliff and I'm sure Margaret will probably do the same thing for me over time. Cliff's favorite thing is to give me these cases that were not traditional, which were not, they were a challenge because I have one tester, and so I don't have comparative information to work from. But let's just walk through what happened here and why laying out and why the testing evidence is so important. I think they have also in their materials the law review article that I wrote on this case.
They have it all.
Okay, so you can read that to your heart's content, but here's what happens. My client, Daniel Chap, and his wife Jean Chap are an interracial couple. She's Japanese and he's white. And as I learned along the way, when they got married in the 1960s, early 1960s, that no Catholic priest in the Archdiocese of Detroit would marry them because they were an interracial couple. How do you like those things? For a guy who, that's all I'm going to say about the Catholic Church here today. They had to have the only black priest in the Archdiocese of Detroit at the time was the only one that was willing to marry him. And the priest in the parish that he belonged to said, I wouldn't marry somebody like you, period. Told him to go away. So, and they ran across many incidents in their lives, which you might expect, regarding their being an interracial couple. Well, they went, they owned some property in Boyne City, Michigan, which is up near north of Traverse City, and went and saw that a house was for sale, a very old Victorian house. And they saw that they had a for sale sign. There was one real estate agent in town. They went to the real estate agent and said they were interested in purchasing the property. And the real estate agent that was there said, why do you want to buy this property? Because it's got problems with it. Why do you want to do this? Now, think about real estate agents for those of us who represent them. Why would any real estate agent ever discourage anybody from buying anything when the bottom line on any of this stuff is money? But anyhow, so they said, look, we want to make an offer. We're going to write up an offer, and made a full price offer, written full price offer. One contingency. They wanted an inspection. So the agent said, sorry, but I can't present this offer. You got to talk to the broker. And the broker meets with them a short time later and says, you know, why are you offering a full price offer on this house? And why do you really want to buy this house? Think about why a real estate agent would do any of those things. He said, okay, I'll go and I'll go to the owner. This was an estate, and I'll talk to the owner about it, but I don't think he's going to be interested in selling. This property's listed for sale. It's got a for sale sign. It's got a listing thing on it. So they go to the owner, and he comes back and he says to him, no, I can't do that. He can't sell the property to you. In the meantime, there was an estate sale on the property. And the owner and his wife are there. My client's there with his wife. And my client knew the owner. His wife did. And my client tried to introduce his wife to the owner's wife. She looked at her and walked away. So they're starting to get some suspicion of something going on. So my client, who's a very persistent guy, goes back to the broker and said, you know, I still would really like to make this offer with this guy. And this is where the first time that religion, I'll tell you, one of the very, very few, maybe John's done one of these things, and maybe he hasn't. Religion cases based on discrimination based on religion that's reported anywhere. He said, you know, the guy said that he can't sell to you because you have a contingency for an inspection, but you also have a contingency for a mortgage, and he can't sell to somebody that's going to have a mortgage on a property because good Christians can't allow other good Christians to go into debt. But, he says, if you will humble yourself and go talk to the seller and pray with him, it's a broker telling him to do this, okay? What's going on with this broker's head? If you go do this, maybe he'll reconsider and sell the property to you. So my guy, he wants the property. He goes and sits down and talks to the guy, and the guy says to him, are you a good Christian? So, well, you know, let's see. Am I a good Christian or not a good Christian? He said, yes, I'm a good Christian. Well, do you believe? He said, yes, I believe. I'll have to pray on it, and I'll have to get back. Because I couldn't sell to you if you're going to get a mortgage, because I can't let a good Christian go into debt. My client says to him, there's never anything in writing. It's a fatal, could have been a fatal issue, but thank God for a judge that didn't see it as a fatal issue. My client made a verbal offer of cash for the whole thing, no mortgage. He said, I got to pray on it. And then 2 or 3 days later, the broker tells him that he prayed on it and he's not going to sell it. So the Fair Housing Center sends out a tester who I interviewed on the phone for the first time before we went in for a preliminary injunction. And you'll see the motion that I filed for the preliminary injunction. So we sent a they said, I didn't, because I didn't know about this case until the testing evidence came in, a non-Asian woman tester who had never tested a property before in her life, but she was good. And she goes to the property. There's no sign on the property. The real estate listing's gone, but she knew where the guy lived and went to the guy's house, knocked on the door, and asked the guy, I understand that this house over here was for sale. Is it still for sale? And he said, it might be. And then he said that there had been a man who had previously offered on the property. Keep in mind, this happens. People tell people that they trust. In race cases, white people tell other white people that they have a trust for, even though this is the first time they're ever seeing that person, this kind of stuff. He said there was a man that was going to pay cash for the home, but the Lord had led him not to sell to the man, and so he took the house off the market. He didn't stop there. As people talk, right? He said he knew that there were laws about discrimination, but he took the property off the market anyhow. And then he said to the tester, if you're really interested in buying the property, you have to come here and meet with us, and you and my wife and I will sit down and we'll pray on it and see if you're the right person to buy the property. So we filed our lawsuit, didn't file for a temporary restraining order, we filed for a hearing on preliminary injunction. And you have in the materials, you have the complaint, you have all the testing evidence laid out in the complaint. And the reason why we did the choice to lay out the testing in this, I needed that for the preliminary injunction. I needed a factual basis in order to support the position that I'm in, that there was housing available, that there was housing that was taken off the market and denied to my guy on the basis of what we argued was religion and race. And I'll, to my dying day, as my clients to their dying days will always believe that Gene Chap being Japanese had something to do with them doing this. We never could ultimately prove that. We had a hearing in front of the judge, and so, you saw my notes, so you can't cheat. So what do you think is the first argument out of the mouths of the lawyers on the other side? John can't say because he saw my cheat sheet notes. Got any ideas of what you had argued in order to defend a case like this? Yeah, First Amendment, free exercise of religion. That's all he was doing. Is it discriminatory to pray on something and based upon prayer decide that somebody is not worthy of getting a property? That's a serious problem in this case, because that's what he's doing, except the question was, he told the tester that for a good Christian, he would have sold the property for cash. But he decided, based upon the conversations with my client, that my client wasn't a good Christian. And that gets us around a free exercise issue. This is a case that was fraught with difficulty going in. If they had had I think, a better lawyer on the other side, I mean, he could have, in today's day and age with what we have with the folk John was talking about, the conservatives, I think he would have seen somebody want to fight this issue all the way on the free exercise issue that's going on there. But I thought we had him on the notion of good versus not good. So you're differentiating between a Christian and another Christian. And I thought if we had to go on that, judge didn't have any problem giving us a preliminary injunction. And ultimately, to this day, 30-some years later, my client still owns that property in Point City, Michigan. You have in the materials another case called Patrick versus Mihai. George Mihai was for those of us who are old enough to know this, was the district court judge in River Rouge, Michigan for 18 years. He owned 2 rental properties in the River Rouge area. My client, a retired military veteran of the first George Bush War, as opposed to the second, came back to Michigan and was looking for a 2-bedroom, two-family flat to buy, so he could rent and he could live in one and rent the other. Makes an offer through a real estate agent. The offer is presented. My client's not there. There's no reason for anybody to know. Everybody in the room is white. The judge, who's about ready to sign the offer, says to the agents involved, wait a minute, I have one more question. Is the buyer who's making this offer white or black? Because if he's black, I'm not going to sell to him. District court judge in Michigan for 18 years. The agent involved, who I don't think should have said what she said, but we could debate this up here. She told him that he was black, killed the deal, took the property off the market. Dan Chapp, from the very first case that we talked about, became the tester in this case. And the exact same thing that happened with him in the prior case with the tester, the judge told him, because he thought he was a veteran, he was posing as a veteran, same qualifications as my client. He told him that he would sell it, the white tester, for less than what my client had offered. And you may know this and you may not know this, but racist folk will spite their nose and lose money in order to live on their principles. You'll see the complaint. It doesn't mention anything about testing at all. So I deliberately didn't put it in there, and I most of the time do not put it in there. It comes out because you have a Rule 26 hearing. It all comes out in federal court fairly quickly on. But I like them to start trying to put their theory together. And what I got was a lawyer when I filed the suit, who, when I had the first meeting with him, said, you know, Obee, you defamed a judge. You've suggested that a judge is racist. You don't know anything about testing. A few weeks later, he calls me and he says, do you have testing evidence? And I sat there when I looked over and I said, yeah. He said, are you going to give it to me? And I said, yeah, of course I'm going to give it to you. I have to give it to you. And as I'm asking my secretary to put this letter together and send it off to her, I'm smiling to myself, saying, wait till he reads this stuff. Wait till he reads what's there about what was offered. I can tell you from then, the money started being offered, and it went like from here to here. And I kept turning down these offers. I had a law firm who was telling me, you know, you're nuts. Take the money. Now, mind you, when the client's eyes get like this at the amount of money they're offering, you know you got a problem. But for my real estate friend over here, and anybody that's ever negotiated with anybody, you know when you got it. And you know that you can always push a little further. always squeezed a little bit more money out of him, and I did. My client didn't get the property, but he got a bunch of cash, which he deserved. Thank you very much. I'll hand it over to Chui.